All right, this is Mr. Bryson. Mr. Bryson has been indicated that you want to enter a plea of guilty to count 1 and 2 of your indictment, and in return you would receive a sentence on count 1 of 8 years to suspended to community corrections. Count 2 would also be 8 years suspended to community corrections on time served. These would be concurrent with each other but consecutive to your violation of probation in Benton County. All right, Mr. Bryson, raise your right hand. Let's place you under oath.
Yes.
Thank you. State your full name for the record.
Christopher Bryson.
Mr. Bryson, you are here today to charge with an indictment, 2 different indictments actually. And are we doing, no, I'm sorry, just the 1 indictment. I was looking at a different case. And there are 2 counts in that indictment. You've heard me go over what the agreement is, but have you seen or been shown a copy of those charges? Talked them over with Mr. Lockhart. You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of guilty. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
Do you understand at trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and Mr. Lockhart could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial.
Yes, sir.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out, which is to suspend your sentence on time served and give you an 8-year sentence with community corrections suspended on time served. Do you understand that?
Yes, sir.
Do you understand that this is going to result in 2 convictions that are going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement?
Yes, sir.
You understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer the questions under oath and on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine you were lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes,
Are
sir.
anybody forcing you to do this against your will?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty?
Yes, sir.
Then are you in fact guilty of these 2 drug possession charges?
Yes, sir.
You want to tell me what happened? What were you possessing?
Methamphetamine.
All right. General, do you want to supplement any facts on this?
Judge, if this case went to trial, the proof would be that on November the 8th of 2023, agents with the Drug Task Force made a traffic stop on I-40 here in Dixon County for speeding and following too closely. Mr. Bryson was the driver of the vehicle. There was a passenger in the vehicle. There was a overwhelming odor of marijuana. There was a probable cause search where MDMA and methamphetamine was located.
All right. I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if you went to trial? You understand that?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Lockhart's done a good job of representing you competently?
Definitely.
Mr. Lockhart, do you know of any reason he should not enter this plea?
I do not, Your Honor.
And Christopher Bryson in docket number 2024 CR 144, upon your plea of guilty to count 1, I find you guilty, sentence you to 8 years in Tennessee Department of Corrections that will be suspended on time served to community corrections. And count 2, you're sentenced to 8 years in community corrections. Those will be concurrent with one another, but consecutive to your violation of probation sentence out of Benton County. Thank you.
Judge, General Stribling wanted me to note that even though this mentions the VOP out of Benton County, Our office has made no agreements on that VOP. It is handled by another district, and we don't have any control of
I
that.
understand. This does not affect whatever Benton County does in that.
Judge,
so.
I don't think I got to review and sign that plea sheet. It also needs to have that forfeit seized property.
I had General Striblin sign it. That's where I was.
Okay.
Break. I went
Thank you,
down
Judge.
All right.
there. I don't mind if the court just wants to write in forfeit property. I don't think that's in the police sheet.
It's not in the plea sheet, but we'll go ahead and do that. So.
Thank you, Judge.
All right. Yeah. All right, I have been handed two documents that are indicating that in docket number 2024 CR 172, the state is being, that charge is being dismissed as a part of the overall settlement of this case, and that in docket number 2025 CR 286, upon a plea of no contest to count 5, the remaining counts are dismissed. Ms. Ellis would receive a sentence of 3 years to serve in the Tennessee Department of Corrections as a range 1 offender, suspended to community corrections. If moved to state probation, there will be no IOT reporting. She would have to undergo monthly drug screenings, attend 2 Narcotics Anonymous meetings a week throughout probation, and pay her court costs. Ms. Ellis, raise your right hand. Let's place you under oath. State your full name for the record.
Ashley Ellis.
Ms. Ellis, you are here today charged with the 2 counts, 2 different indictments, and you've heard me go over what the agreement is. But have you seen or been shown a copy of those charges, gone over with Ms. Wainick, what those charges are, what the evidence is, and any possible defenses you might have? Do you feel like you fully understand what you're charged with? Do you understand that a plea of no contest means you are not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial, and their evidence would be used by me to find you guilty according to this agreement? Do you understand that? Do you understand you have the right to plead not guilty and have a speedy and public trial by jury in this court? Do you understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own? You understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything. Do you understand that if you went to trial, you and Ms. Wainick could confront and cross-examine every witness the state called to testify against you, and you could bring in favorable witnesses of your own by using a subpoena? Do you understand at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal? Yes. Do you understand by pleading no contest, you're waiving your right to a trial and to an appeal, and all I'm going to do is approve what your lawyer has worked out? You understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime. You understand everything I've explained to you?
Yes, sir.
Do you wish to plead no contest according to this agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will? Do you understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial. General?
Judge, if this case went to trial, the proof would be that on September the 28th of 2025, Ms. Ellis was a passenger in a vehicle that was stopped here in Dixon County on Interstate 44, going 91 miles an hour in a 70 mile per hour zone. Over the course of the investigation, officers observed evidence, and then Ms. Ellis admitted that the officers had seen her reaching into a yellow bag, and she was trying to dispose of a white powdery substance in attempt to conceal it from the officers. That substance ended up being a narcotic.
All right, I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be if you went to trial. You still wish to plead no contest? Are you satisfied with your attorney's services?
Sir.
You feel like Ms. Wainick's done a good job of representing you competently?
Sir.
Ms. Wainick, do you know of any reason she should not enter this plea?
I do not.
Anything further from the state? Then Ashley Daniel Ellis in docket number 2025 CR 286. Upon your plea of no contest to count 5, the remaining counts are dismissed. I find you guilty, sentence you to 3 years in Tennessee Department of Corrections as a range 1 offender that will be suspended to community corrections. If you are successful in community corrections and move to state probation, there will be no IOT reporting, mandatory monthly drug screenings, and you will be required to attend 2 Narcotics Anonymous meetings a week throughout your probation. You're also ordered to pay the court costs. Docket number 2024 CR 172 is dismissed as a part of this agreement. Thank you.
Your Honor, I'm stepping up to the podium. I think that my office may have already, can I stand here? Thank you. Has already been appointed, I think, Your Honor, or this may be an arraignment today. I'm not exactly sure exactly. Thank you, Madam Clerk. This is, oh, sure. I've got this case set for a status on Your Honor's docket. His new charges, not this case, but his new charges on September 8th. I thought if we could put this on the same date. that'd
All
make a
right,
lot of
September
sense.
8th.
Thank you, Your Honor.
You are Mark Edwin Seaborn, is that correct?
Yes, sir.
Mr. Seaborn, you're charged here in a multi-count indictment with rape, incest, statutory rape by an authority figure, especially aggravated sexual exploitation of a minor, solicitation of a minor for rape, and solicitation of a minor for especially aggravated sexual exploitation of a minor. Previously, we had indicated that you had a lawyer or that you were going to hire a lawyer, but that's not been consummated, is that correct?
That's correct.
Are you able to hire a lawyer, or do I need to appoint the public defender's office to represent you?
I need an attorney, Your Honor.
You need someone appointed?
Yes, sir.
All right, I'm going to appoint the public defender to represent you on these charges. Mr. Talbot's here with the public defender.
Yes, Your Honor.
We'll show that I think he's already been arraigned, so we'll show that you are the lawyer. And are we setting a status day in September, General? Or does it have a date? This was his status day, so we'll need to set a status. I would suggest September the 23rd.
Yes, sir.
All right, September 23rd. That's a day to let your lawyer get familiar with your case, discuss it with you, and get the discovery necessary so that we can decide whether or not you're going to try to resolve it by an agreement or we need to set you a trial date, okay? All right, thank you. All right, this is the State versus Sherrick, Markey Vaughn. Mr. Vaughn, in docket number 2022 CR 336, in which you were convicted by trial by jury, and you were convicted for retaliation for past action, sentenced to, I believe it was 6 years in Tennessee Department of Corrections. You have filed a motion for new trial, as well as a motion for new trial in your case, docket number 2024 CR 142, which was failure to appear. So today is the hearing date for your motion for new trial in both of those cases. Are you ready to proceed on that?
Your Honor, I have more motions filed than that. I have also a motion for acquittal. And if it could, can I get a copy of those motions? Because I got transferred to TDOC and all my records has been destroyed. I have not a copy of none of this stuff.
I can have the clerk run a copy of your motions and give it to you, but will mean that we'll have to come back to you a little later in the
That's fine.
day. So, all right. If you will please run a copy of the motions, and then we will come back to Mr. Vaughn.
Judge, I have a copy of the motion for new trial and the amended motion for new trial. I'm looking to see, I may not have the additional motions that he's referring to.
Yes, sir. There's a motion for acquittal, a motion of stay of judgment. There's a subpoena for the chiefs of the jail. There's a subpoena for Jennifer Dozier to testify today. And I got 2 more here. If you can have somebody come get them, I would like to add an amendment. You granted me amendment. I got this page, if you can tear it out.
We're going to have the clerk make a copy of all the motions that you filed, and General, you may want to look at those copies before we deliver them to him to make sure you have the same copies.
This page.
And we will come back to you. Just if you'll step back with the officers until after those copies are run, it'll be later in the day. I will need a copy of those as well, I guess, if you'll have her run a couple of copies.
And Judge, I do see the request for subpoena. Were any subpoenas issued for today?
There's a request for a subpoena for Jennifer Dozier.
And, what's this captain's name, or chief? Jail administration, there was requested here today too.
And how does that factor into your motion for new trial?
It factors in because I put in a motion for acquittal. It factors in because the chief from the jail can testify who has authority once someone enters into their facility, and Jennifer Dozier's testimony can testify to a sequestered witness.
All right. Well, have those subpoenas been served?
No, they haven't.
Then we'll necessarily have to reset your motions in order to get those subpoenas served, if that's what. So we will reset you for September the 23rd in order that those subpoenas be accomplished to serve on those individuals that he's requesting, and that they be brought in on September the 23rd for a hearing on these motions. All right, we'll see you September the 23rd, and those subpoenas that's ample time for those subpoenas to get served, so they should be served.
Okay. You should make sure I get a copy before I leave of all those two.
We'll give you a copy before you leave. So.
All right, thank you.
All right, Mr. Devaney, you are here today because you filed a pro se motion for jail credits, and it's alleged that you are not getting credit for your 30 days that you served on weekends. Is that
Yes.
what I'm understanding?
Yes, sir. I have a record sheet right here from Deputy Gonzalez, if you,
Well, you want to demonstrate that to the bailiff, and let me see what it says. So this is the weekend days that you're talking about?
yes, sir.
You need to hold on to that, or at least let the clerk make a copy of it. But what I'm going to do, calculating the days, General, do you know anything about this?
I just want to state to the court that the state did prepare an amended probation revocation order back in March that included 10 days of the
Well, let's let you show that to him, and
these are what the amended order were 2024.
you can tell.
You're happy to take a copy of that?
Well, let me explain to you that what's going to happen is I'm going to have to appoint the public defender to represent you on this motion for jail credits. That's what I typically do in all these cases, because I can't sit down and calculate whether or not you're getting those days. I'm going to put somebody on your case that will help you to make sure you're getting the correct amount. And if there's an amendment to the judgment form that needs to be entered, then they'll help prepare that and get it done. So, Ms. Rhonda, I'm going to appoint the Public Defender's Office to represent Mr. Devaney on his pre-sentence, pro se motion for jail credits, and then obviously they need to check with the state and get what they've got. But he also has a copy of what he says are the days that he served that he's not being credited for. So, all right, they'll be in touch with you to try to get that cleared up, okay?
Okay. When, will that be done today, or will it be?
Not likely to be done today, but it's likely to be done in the next few days anyway, so.
Thank you.